Now, it's my pleasure to moderate this seventh panel, which is most importantly the last of the day, but is also a very interesting one. It's concerned with cyber attacks, the law. And we have a truly international panel here. We have a panelist from the United States of America, a panelist from the United Kingdom, and a panelist from Essex. So welcome to all of you. Now, we've established, no doubt, with an alarming degree of certainty that cyber operations are, of course, governed by international law. And we've just heard in the previous panel that cyber operations that are executed in the context of an armed conflict are subject to the law of armed conflict. So the purpose of this panel, therefore, is to consider the more specific issue of how international humanitarian law applies to attacks. And of course, even that brief statement of the purpose of this panel immediately raises important issues. For example, what is an attack within the context of cyber operations? Is it simply an attack involving the movement of electronic information between physical elements of a cyber infrastructure? What is a lawful target in cyber operations? Now, assuming that we do agree on what constitutes a lawful target within the cyber context, then it becomes important to consider the means and methods of attack. Do the established rules of international humanitarian law apply to cyber attacks? Or are there particular features of cyber weapons that make such a proposition difficult to apply in practice? And similar considerations apply in respect of precautions in attack. In relation to cyber operations, which we have heard are often not susceptible to geographical constraints and limitations, what is the test to be applied in taking precautions? How does one assess feasibility in this context? As I say, we're very fortunate in having a deeply expert panel to help us guide us through these issues. Air Commodore Boothby is a retired RAF lawyer who will consider means and methods of attack. Professor Eric Jensen of Brigham Young University is a former US Army JAG who will then consider precautions in attack. But first of all, immediately to my right, Dr. Noam Lubell, Reader in Law at the School of Law and Human Rights Centre at the University of Essex, will talk about lawful targets in cyber operations.
Thank you very much, Andrew. And first of all, I'd like to thank the Naval War College and Professor Mike Schmidt and his team for the invitation and organization. It's a pleasure to be here. What I'm not going to do is, and despite sort of me being meant to talk about military objectives, I'm not going to run through the definition of what is a military objective. The agreements and disagreements, I think, are fairly well known to this crowd. Instead, what I'm going to try and do is focus on the areas where the cybersphere presents us with challenges in determining what is or is not a lawful target in this context. And before I go any further, just to clarify a preliminary matter, and Mike already mentioned this, but I think it's crucial, particularly because I'm going to speak a lot about the notion of attacks, is the separation between the ad bellum and the in bello when we talk about attacks. We've seen this in the previous panels. There's a debate with regard to the use of ad bellum as to whether something could be considered an armed attack, if you're talking about a cyber operation, one that would trigger self-defense. But the response to that question doesn't provide us with the answer as to whether the object that was attacked would have been a lawful target under the jus in bello. The debate over defining something as an attack under the ad bellum can occur regardless of the military nature or not of the object being attacked. Again, that's in the context of the ad bellum. Moreover, the threshold for an armed attack in the jus ad bellum is not necessarily the same as the definition of attack in the jus in bello. So just that should be borne in mind when we're talking now about attacks in the jus in bello, and not to sort of keep thinking that everything that's said here necessarily relates in the same way to the concept of armed attack under the jus ad bellum. So this is just about the jus in bello and what occurs during an armed conflict. Now, commentators have used the term cyber attack to cover a wide range of operations. Now, we've heard the phrase cyber attack being used to discuss hacking into DoD emails or even Google servers, or more generally, one of the definitions speaks of any action taken through the use of computer networks to disrupt, deny, degrade, or destroy information resident in computers and computer networks, or the computers and networks themselves. Now, I'd say probably almost a dangerous ease with which we use the word attack causes us to unwittingly slide into an assumption that all of these operations require an analysis under the laws of armed conflict. And here I'd agree with the observation made in one of the earlier panels that not all cyber operations necessarily require an analysis under the laws of armed conflict. In fact, many of them probably don't. But that being said, this particular presentation, now my focus is on those operations that occur in the context of operations being conducted by one party to a conflict against another party to a conflict. Right? So in circumstances in which the laws of armed conflict have already been triggered. So within that framework now, I want to question this issue of lawful targets. And one of the most complex challenges arising here is, what do we do with the possibility that some cyber operations within an armed conflict might not meet this definition of attack? How would we deal with that? And does that perhaps expand the bank of lawful targets for these operations? And this would require an analysis of the concept of attack in the cyber context. And the implications are of crucial significance. Think, for example, of a denial of service attack against a website. Okay. If this is what we call an attack, then the nature of that website, can it be categorized as a military objective or not? Well, that'll determine the legality of the attack. But what happens if denial of service is not an attack as we understand in the laws of armed conflict? How would this affect the legality of targeting it in a cyber operation? In other words, would the nature of the website being targeted even matter? Can one engage in cyber operations against civilian objects by saying, well, these aren't attacks as we understand in the law of armed conflict? Now, the debate on this has produced a number of different opinions, and this has been reflected in the discussions over the Italian manual, which was mentioned earlier, and I'd like to add some thoughts of my own to this. One existing view is that most cyber operations would be an attack because the definition of military objectives includes acts of neutralizing, which are often the effects of cyber operations. But this approach has been countered, and rightly so, I'd say, by noting that the definition of military objectives from which the neutralization notion comes only becomes relevant once we've had an attack. And if it's not an attack in the first place, then we don't reach this military objective definition where we start talking about neutralizing. Now, a second approach posits that since the concept of attack requires that its effects include casualties or significant damage to property, then many cyber operations wouldn't actually be attacks. Otherwise, it's argued, we could end up with a situation where any minor disruption to civilian networks would be prohibited. And so cyber operations are therefore said to be often more akin to psychological operations, which don't have violent effects and might be permissible even when directed at civilian networks. Now, I'd agree in principle with a lot of this approach, but I think it's necessary to add some crucial caveats. First, I think we need to be careful with this analogy between cyber operations and psychological operations. Disseminating propaganda is a perfect example of psychological operations. Now, those types of operations can be directed against civilian population, attempting to convince them, for example, to abandon support for their leadership. But those aren't considered to be operations that cause direct harm to civilians, whereas cyber operations might do so, even if you don't measure it in casualties. And we need to acknowledge a difference between morale and harm in that sense. Outside of propaganda, what type of analogy could we draw between cyber operations and psychological operations? If we're talking about cyber operations that are designed to have some kind of adverse effect on the civilian population, for example, putting pressure on them by causing damage to communication networks or power supplies and so on, well, then probably we would be causing the kind of harm that would cross the threshold into attacks. So in other words, it's not that the cyber operations are akin to psychological operations because of the cyber format. Rather, it's that we might have some specific cyber operations that are analogous because their intention and their produced effect is, well, little more than attempts at lowering morale of the enemy population. But this isn't necessarily true. In fact, it's probably not true of the majority of cyber operations. And if that's the case, then an overall analogy between cyber operations and psychological operations is probably too sweeping of a generalization. It's already acknowledged by the second approach I mentioned earlier that cyber operations which do result in casualties or property damage might be categorized as attacks. However, I'd argue that the thresholds might be a little different from physical damage. The concept of violence, for example, is not only physical. It can include, for example, mental violence. We know this, it's well documented from areas such as the prohibition of torture. I'm not going to argue here that cutting off the civilian population from their emails for a few days causes mental distress at the level of torture, although that might be true for some of us. But what I do want to point out is that when we're looking at the effects of cyber operations in order to ascertain whether they should be considered as attacks or not, we perhaps do need to look wider than physical casualties and destruction. The dividing line is not so much the format of the attack or even the physical violence, but I would argue it should be the level of harm caused. And note that I'm not saying any harm. There is some kind of threshold, but I would just say that perhaps the threshold is not necessarily physical damage or casualties. Now, this brings me back to this notion of classifying the cyber operation as an attack or not based on its effect. And an emerging view, which Mike mentioned, which has come through in the latest draft of the Italian manual, is this idea of a functionality approach. And at least the way it's being presented at this stage is that defining criteria can be the effect on the functionality of the targeted object, and if the functionality is impaired to the point which requires replacement of parts, then this still fits in the concept of attack. Now, this approach isn't so much a compromise between the two views we mentioned earlier. It's really more of a fine-tuning of the physical damage approach, whereby the test for damage now includes functionality. But it's still, at least, again, in the way it's currently formulated, it still requires replacement of parts. So it's still, in that sense, tied in very much to the notion of physical damage. It might be expanded a little more, and Mike mentioned that, say, if rebooting might count, or not. Reloading. So, okay, reloading the system. But at least the way it's drafted right now is still talking about replacement of parts, in which case it's very much tied into physical damage. Now, I want to play perhaps devil's advocate here on this question of physical damage. And I say I'm playing devil's advocate because I'm not necessarily presenting my own position. I'm not sure what my position is yet. I'm doing a very dangerous thing here in this presentation. I'm thinking out loud. And usually when I started with a slightly different position, and usually when I'm trying to engage in sort of thinking about something, I try and construct the best counter arguments I can come up with to challenge myself. So I'm just basically, I want to share some of these questions that I'm grappling with regard to this notion of physical damage. And essentially, the key question here is whether this insistence on remaining focused on physical damage is a position that we might need to rethink, at least to a certain extent. Consider this, for example. Insisting on physical damage means that blocking enemy communications by physically sabotaging the telephone lines or fiber optic cables would be an attack. But completely disabling the same communication networks in a cyber operation but in a way that doesn't damage physical property or require replacements of parts, would not be an attack. Now, what's the basis for this distinction? The military advantage gained, the effects can be almost identical. Surely it's not because one of these requires us to reposition a telephone pole and the other doesn't. That would be an arbitrary distinction that doesn't really seem to take account of modern reality. This is also linked to a question of the definition of military objectives and whether, for example, and this is taking it one step further, whether we can consider data as an object when we're talking about military objectives. And I recognize this is a very controversial notion, but I think it does require some thought. If you look at the ICRC commentary to Additional Protocol 1, when they're talking about military objectives, it says that an object is something which is visible and tangible. Now, clearly, I'm not going to argue with that, clearly, visible and tangible, that does not seem to include data. Okay? And at the same time, it's unlikely that they would have, at that moment, contemplated data the way we use it now. And I think it's useful, perhaps, to look not only at what they considered to be an object, but also what they were ruling out. So to try and get an idea of how we're supposed to understand this concept of objects. And the reference, if you look at the commentary, the reference to something being tangible and visible is made in order to distinguish objects from the very different concept of military objective in the sense of aim or purpose. Right? So they were trying to distinguish between things and between objectives as in an aim or purpose. And I think it's at least arguable or worth considering that data is closer to what they wanted to include as objects than it is to what they wanted to exclude as aim or purpose. Now, the question of destroying data also raises an interesting matter as to the relevance of existing backup data. Because one of the arguments might be, well, damage hasn't occurred if the data can be retrieved. But the question of potential restoration capability, well, I'm not sure that that's the correct test for determining the nature of an object and the legality of targeting it. Most physical property is not irretrievable. Buildings can be rebuilt. Cars can be remanufactured. It's usually just a question of cost. Now, restoration of complex digital data can be retrieved, but there'll often be a cost there as well. So why is causing one costly act more lawful than the other? Is it just a question of degree, of time and money involved? I think the answer to a lot of this debate might be found by remembering that actually this whole debate, why are we having it? Why is there this desire to exclude certain things from attacks? Well, it's because we want to exclude certain operations from the definition of attacks so that we don't end up describing minor disruption to civilian networks as unlawful. But this concern isn't really as great as it seems, because note, we're speaking here of direct attacks against civilian networks. Okay? Now, we're not talking about attacks against dual-use networks. Direct attacks on civilian networks intending to cause negative effects in that sense shouldn't really not be an encouraged activity in the context of armed conflicts. And by ensuring that these operations are considered as attacks, and therefore we shouldn't be targeting civilian networks, we can afford better protection to civilians. At the same time, having this lower threshold of toleration for operations against pure civilian networks won't have a detrimental effect on military needs if it doesn't prevent attacks on dual-use networks. Right? These can be legitimate military objectives. And if our primary concern is the latter, then this whole debate is really misplaced, because defining the operation as an attack would still allow for the dual-use target to be a legitimate military objective. We'd have problems then with indiscriminate attacks, proportionality, whether the harm caused to the civilians is acceptable disruption, or whether it influences the proportionality formula. That I'll leave to Eric in the next presentation. But it's not a question of whether we can actually target it or not. If it's dual-use, we can. If it's civilian, maybe we shouldn't be. A final point on the question of whether cyber operations are attacks is a reminder that in other contexts, states have rightly clarified that when analyzing the legality of an attack, one needs to look at the attack as a whole. So recognizing that a specific operation might be, as described in the book of one leading commentator who happens to be here, a single segment of a complex mosaic. And if we're applying this to the question at hand, you could argue that if a cyber operation that alone might not have been described as an attack is in fact an inherent component of a collection of operations that form a single attack, then this cyber operation needs to be assessed within the laws that apply to attacks, including the question of its target. For example, disabling a communications network for a few hours might not cause serious harm on its own, but if this is carried out in order to mask other activity that enables a devastating attack to occur while the enemy cannot communicate, then clearly the cyber operation was part of the attack. But notwithstanding all of the above points I've just made, there will still be a certain threshold below which, and however high or low we set that, below that threshold, certain cyber operations would not be attacks. And we've spoken about sort of espionage-related activities and so on, and there are all sorts of examples that could fit in here. And if that's the case, then the law of armed conflict might not prohibit such an operation, even if it's directed at a civilian network. But we should remember that even if that's the case, the law of armed conflict isn't the only legal framework in existence, of course. These operations wouldn't take place in a legal vacuum. Hopefully we've learned the lesson in recent years of trying to claim that we have legal black holes that we can operate within. And depending on the precise circumstances, there will be a host of other laws that would play a role, ranging from telecommunication laws, principles of non-intervention, human rights law, bilateral treaties, trade agreements. All of these could affect the legality of operations that might not come within the laws of armed conflict. I want to just, before ending, I want to move on very briefly to just to give an example of a couple of the more traditional debates that occur in the context of looking at lawful targets, military objectives. One of these, for example, is whether certain industries can be targeted, can be lawful targets. For example, is it lawful to target a factory that's producing computer hardware or software? Well, if this hardware or software is something that's specifically designed and intended for use by the military in its operations, then you could probably make the analogy here to weapons factories and say that it would be a lawful target. If, however, we're talking about more generalized production of computer equipment, which further down the line, some of it is used within military systems, we're probably coming closer to, let's say, in the traditional analogies, an industrial steel plant. And here the effective contribution to military action perhaps isn't as direct, but is possibly enough still to render this factory a military objective. Another challenge, and one of the sort of the traditional debates that we have, is the question of economic targets. And of course, on this side of the Atlantic, this notion of war-sustaining capabilities and whether we can target objects of that type. And the debates over this approach aren't new, and again, don't need to be repeated here. But we should probably note that the cybersphere presents a heavy temptation to use operations of this type because of the ease with which we can carry out or cause financial damage. So it makes it even more important, perhaps, the cyber sphere makes it even more important to try and clarify and reach a certain agreement on this particular debate, because we're likely to see it come up a lot more than we did outside of the cyber context. So I'll sum up by saying that, in my view, a key concern when we're talking about lawful targets in the cyber context is when you want to determine the legality of targeting a certain object, a main question here will be whether the operation is going to be an attack and therefore subject to the law of armed conflict principle of distinction or not. And specifically, there's a question of whether we can apply this analogy from kinetic force and focus on physical damage. I think we might need to rethink the focus on physical damage. But if so, our challenge right now is to try and find a new and workable threshold of harm in order to satisfy the notion of attack. Most of the other issues, I think, don't present unique challenges in the cyber sphere, but nevertheless might confront us more often than they do outside of it. And I'll end here. Thank you. Over to you.
Okay. Okay, I think I have some slides. We'll see if I do. Let me first of all say thank you again to everybody who's been here participating. I've been as impressed with the conversations in the hallways as I have with conversations here. I think probably any of you could come and sit on this panel and do equally well. This has been an amazing gathering of people, and I appreciate being invited to be here. Let me just give you a bit of a caveat. This story is told by Sean Watts, for those of you who know him, but I'm in the exact same position. He and I both started in the military as tankers, not as a tanker, as a guy who was in charge of tanks. You know, it'd be hard to be a tanker, I guess, and I'd be an object that could be attacked. As people who drove tanks or who commanded tank platoons, or in my case, a cavalry platoon. And to just show you my technical savviness and expertise, particularly with cyber stuff, every time, you know, you go down to the motor pool to try and work on your vehicle, and my gunner and my loader and my driver would be there. And every time I'd go to do something, my gunner would say, don't touch that, sir. Don't touch that. Oh, okay. And then I'd go to do something. Don't touch that, sir. Don't touch that. And that's basically how I am in terms of technical capability here in cyber stuff. So that's my cyber technical disclaimer. I want to just respond. Could you go to the? Oh, I can go to the next slide. Let's see if I can. Hey, this is the outline that I'm going to cover. I'm going to hit each one of these spots briefly. Starting with the underlying factors, I think in one sense I want to respond a little bit to what Noam said, and maybe it's just a matter of semantics. You know, I think that the law is fairly clear that we will never target civilians or civilian objects. I mean, that's the law there is pretty clear, right? So the question is not about whether we will target civilians or civilian objects with what is an attack. It's in terms of an attack, it's what collateral damage or other effects we might have on civilians. Now, the reason the definition of attack is so important is because that doesn't mean that we can't do anything to civilians, right? I mean, we can do things. There is nothing that says we can't do things to civilians that might cause them irritation or distress or things like that. That's not precluded by the law. And I don't want to get into this discussion of attack too much again because Noam's talked about it. There's the Schmidt-Dortmund argument that Professor Schmidt's already referred to. Paul Walker, who was here yesterday, has written a great article on acts of violence and how it equates. But I just think it's important to note that that there are some things we can do, and the reason this question of attack is so important is because you know you can't attack civilians, but if it's not an attack, then there are some things that cyber opportunities may allow you to do to civilians that might forge your aims. And the second point is, again, I'm not going to go over this in any great detail because particularly Mike's talked about it, but we have to consider, particularly for the things that I'm about to talk to you about, we have to consider states and non-states and how they fit into this. I am going to talk about precautions in the attack. Well, so that presupposes that we're talking about attack. So you have to presuppose an attack for the information that I'm going to talk with you about. And you have to presuppose that it's the right person. You know, all of these things are kind of underlying factors that you have to assume before we get into my discussion. I don't want to talk about them, but I want to highlight the fact that you have to give me those assumptions as I talk to you about what I'm going to talk with you about. So let's start then with the duty to constant care. Now that I've just said everything I'm going to talk about has to do with an attack, I'm going to immediately not talk about something that has to do with attack, right? So here is the law in Article 57.1. This is the first kind of provision under precautions in the attack, and it talks about something that is, in fact, not an attack. And I think this is an important distinction. In fact, if I could only draw one distinction from this, I would draw the distinction to the fact that this is not about an attack. This is a provision about constant care, taking constant care. I believe this is binding on all states in both IAC and NIAC. Constant care, of course, is not defined. It's not clearly defined in the commentary or any other place. I think what we can say without much doubt is that it must at least mean that commanders cannot ignore the effects of their cyber operations on civilians. Now, beyond that, we're going to have to work out what the details are, but this provision applies to all cyber operations, not cyber attacks. Every time a commander decides to do a cyber operation, he has to meet this legal definition. He has to take constant care to spare the civilians. So that is a that requires a situational awareness on your cyber operations that will allow you to meet this legal standard. For example, think about Stuxnet, right? So Stuxnet, we can argue about how discriminatory it was, how well targeted it was, but at some point, if we assume that its target was the Iranian nuclear facilities, at some point it cut a broader swath than that, right? Well, so potentially, again, I don't know the facts enough to know the truth of this, but assume a weapon like that, there would be a requirement on whoever launched that weapon, whatever state launched that weapon, to contain that weapon or that tool such that it spared the civilian population. We know that Stuxnet itself spread beyond. Now, it didn't spread, like the I love you virus, but it spread beyond supposedly its target. A commander who had ordered that would have an obligation under this provision to somehow continuously give constant care to try and contain that. Now, just to throw a wrench in the works of that, I think that's fairly uncontroversial, but I imagine that most of you have read Ellen Nakashima's recent article about Flame, where she alleges that the reason Flame was discovered was because it was sitting resident on a number of Iranian servers, and that the Israelis were doing other things on those servers that caused some kind of commotion such that the Iranians came and looked and, oh, wow, it's not just this commotion, but there's also this flame thing. So I think this constant care, my concern is that if this is true as it played out, you will find commanders who will say, I've got my obligation for constant care, but remember the flame example, because people were doing stuff in the system, that's what caused the discovery of the malware. I don't think a commander can say, by maintaining constant care, by maintaining continuous a view of what is going on in the network, by trying to contain what's going on in the network, it might trigger someone to look at the network and therefore discover my cyber operation. Therefore, I am not going to take constant care. I don't think that's what the legal standard is. Now, let me just flop the virtual coin around for a minute. I wonder, and I don't actually know the answer to this and would be interested in your comments, I wonder if this is not only a caution but also an authorization. Could a military use this provision to say, I have an obligation to maintain constant care, I have an obligation to continuously to make sure that my operation will spare the civilian population, will not cause additional damage, whatever. Therefore, I have a legal authorization to enter networks to make sure I can scope them, to make sure I can map them, to make sure I can contain all of that. So what I'm wondering, what I need to spend more time thinking, and what I would like your thoughts on is whether you think, or to what extent you think, this provision could also work as an authorization for a military commander to go into networks to say, well, I've got to do this in order to fulfill my requirement under 57.1. All right, next I'm going to talk briefly about proportionality. There is the standard. Again, I believe this standard is binding on all states in both IAC and NIAC, and there are a list of issues that we could talk, we could have a whole conference just on this one principle. I'm going to talk really about two pieces of this and both briefly. One is the damage to civilian objects, and the other is indirect effects. I think that, again, I'll go back to what we were talking about with attacks in a sense. Most would agree that damage to civilian objects is more than inconvenience, irritation, stress, or fear. And that then there is this question of functionality. Does functionality, if we're going to include functionality in this, does it mean that there is a hardware fix, that there has to be replacement parts? Does it mean that it can also be something less than that? I think that is undecided. I'm anxious to see where the Talon manual comes out on that issue. Indirect effects. Again, this is not a prohibition on all indirect effects. It's only a prohibition on all indirect effects that should be expected. No, I think I'm still good. A prohibition on all indirect effects that should be expected. So, This has already had an impact on our overseas operations. You all have read in the papers about the fact that some U.S. entity was planning on attacking Saddam Hussein's financial networks, but did not because of the indirect effects they thought it might have, that they thought could be expected to occur in the European financial network. So this has already played out in state practice where a state has not taken an in bello attack, an in bello cyber attack because of potential cyber effects. Now, this is obviously tied to the duty of constant care, right? You cannot be able to appropriately apply this unless you are maintaining constant care. So there's clearly a link here. You must map the networks. I mean, that's part of this. You have to consider, I believe you have to consider the transfer on portable storage devices. We know that that's how some people allege Stuxnet made the air gap jump. I think that at some point a commander is going to have to say, when he's considering his indirect effects, he's going to have to say, how much, given the tool I'm using, the way I'm using it, what are the chances that this is going to make a portable storage device jump to a network or a system that I do not believe it should be on, that I think will cause indirect effects, cascading effects, whatever you want to call them. What is the chance of that? And then the commander would have to apply that as part of his proportionality analysis. Again, I think that there is a continuous responsibility to monitor, because when we get to indiscriminate attacks, of course, you have a commander who starts an attack or is contemplating attack must maintain the ability to cancel or suspend if the indirect effects become such that the proportionality analysis would prevent him from doing that attack. Again, you go back to the Israel example, or the example of flame being discovered because of Israel. Again, this is all how it's reported, Israeli tampering with the oil and gas industry in Iran. Okay, so the next standard is feasibility. Am I moving through this fast enough for you? Feasibility, it is again not defined. It applies, it's basically the standard that applies to, it's not defined in the text. It is basically the standard that applies to all precautions in attack. There are a few exceptions. For example, 57.4 talks about air and sea operations. It doesn't apply that. The standard there is all reasonable. But it does apply, for example, to verification of targets. It does apply to the choice of means and methods. It does apply to precautions against the effects of attack. Feasibility is the standard for all of these. It is generally understood to mean those things which are practicable or practicably possible. So practicable or practically possible, taking into account the circumstances ruling at the time. If the standard for conducting an attack is you must take feasible precautions, then those precautions must be those precautions which are practicable or practicably possible at the time. That does not mean all precautions. It does not mean no precautions. It means somewhere in between those two. The words that we use, again, are practicable or practicably possible. This is clearly tied to technology, right? I mean, it applies to both the tool and to how it is used. Both the tool and how it is used. And, of course, it ties back into that constant care standard. But so let me give you just some things that I think about this that cause me some concern about the ability for a commander to apply this in a good way in the cyber context. If gathering information, i.e. mapping the network, i.e. exercising constant care, is not practicable, then the attack is probably going to have to be called off because it would be potentially indiscriminate. However, because everybody has different layers and capabilities of technology, we have this discussion about precision-guided munitions, right? Because everybody has different layers of technology and different capabilities in technology, can a commander from an under-technologicalized, computerized country say, my requirement or what is practicable or practicably possible for me is lower, that standard is lower, than what is practicable or practicably possible for the US or Israel or the UK or China or Russia, etc. I think that's a question that could cause us some concern as we go down the road, just as it has with PGMs to some extent up till now. The second piece of that then is, according to circumstances ruling at the time, you all know the Rendulic rule, our good friend General Lothar Rendulic. This is not a perfect science, obviously. This is not a perfect science, just as General Rendulic's assessment of the Russians coming up Finnmark was not a perfect science. But remember, it has to be a reasonable decision, right? I mean, you have to, it's reasonability, the reasonableness of your decision that will be the standard when you're sitting in front of the ICC. Okay, let me go now to precautions against the effects of attack. This is an area where I think, to be honest, I think that most developed nations, and I can at least speak for the U.S., have just said this is too hard, so we're just going to kind of ignore this, or we're going to explain this away. I think this is an area where if we were truly being right with our legal obligations, we would have to do some significant alteration of how we move forward. So here is the law. At least this is the first part of the law. There are three sections to this. There is A, B, and then there is C. A and B are what I would call segregation, the responsibility to segregate. C is what I will call the responsibility to protect. Now, note that this is not a wartime standard. In other words, with proportionality, right, that's a wartime standard. You don't apply that principle unless you're in the attack. But precautions against the effects of attack, you have to start applying that standard long before armed conflict exists. Otherwise, you have not properly segregated. You may not have put in the processes to properly protect. So it's not just a wartime standard. Segregation, as you can see up there, what is it? When it was originally made, I think this rule obviously was geographically centered, geographically focused. I mean, you can read the words, you can sense the geographic aspects of this. And yet, for at least Department of Defense, I mean, estimates are between 90 and 95% of DoD traffic flows over civilian infrastructure. Does that mean because that is the current existence of the state of things that we can throw up our arms and say, well, okay, that's segregate thing. We're beyond that. Let's not do that. I think we cannot do that. I think we have to make two distinctions, one between traffic and one between infrastructure. So in other words, even if we say we can't segregate traffic, does that mean we can't segregate infrastructure? And do we still have an obligation to segregate infrastructure to the extent that it is feasible? You'll note that the very lawyerly written last piece of that first paragraph, which says to the maximum extent feasible, right? So we're back to that feasible. That's the standard again here. But to the maximum extent feasible, we have an obligation to do that. Now think back to Colonel Reed's discussion about cloud computing. DoD has made the decision to move to the cloud because of the cost savings. If we accepted this obligation in cyber as it seems to apply by its words, are we really segregating ourselves by now transitioning all of our DoD data onto the cloud and using that as our infrastructure to hold our stuff? I don't know. I think that's a question that deserves more attention. I'm not convinced. Let's move on to protect. That's the C part of this. I'll give you a chance to read it. Again, the maximum extent feasible applies to this. What is it we're actually protecting from? We're protecting from dangers, right? Dangers. That again, we're not talking about inconvenience. We're not talking about irritation. We have to protect from dangers. This might be considered equivalent to the discussion on proportionality, and it might even again include functionality again in that. Who do we protect? Well, we protect stuff that is under our control. What does under our control mean? Well, again, originally this was clearly a territorial standard. Can that still be right, that it's a territorial standard? You all have read about the Internet in the Suitcase initiative, right? Where we're gonna send some dudes into some place. We're gonna pop open the suitcase, and it's gonna provide a temporary Internet. I actually talked to the guy who claims to be one of the contractors who's working on this, and he says that the news had it reported all wrong. Maybe it does, but you have, if there is that possibility, or just think about the possibilities of moving your internet around. Does it make that territorial aspect of this seem right? And what are the obligations to protect? Does that mean cyber warnings to your own people? In other words, is it sufficient for the NSA to give a cyber warning to Microsoft and say, hey, we're at armed conflict with China. We think they're going to attack you. Here is your warning. You've been warned. Good luck. And you also have read the recent news articles about Google now saying that Google will issue these warnings, right? Google is now taking it upon themselves to issue people warnings that they are the targets of state actors, of state hacking. what if Google gives you that? Can we rely on Google? We'll just say, look, Google, they monitor traffic. We'll just let Google protect you, or at least warn you when you need to be protected. There was a little bit mentioned earlier about regulation in the DIB pilot, how that's gone. I think that at least if we really embrace this idea of under our control and the responsibility to protect, we're going to have to do more with regulation like we have done with the defense industrial base than we have. And then finally, what is our response? How do we respond to this idea that we have to protect things under our control? I think there are lots of ideas out there. I think one of them, which I have advocated in the past along with others, is this idea of a strategic cyber reserve. If we believe that we need to protect certain industries, certain targets that are under our control from attack, if we can't protect them, can we provide them alternatives? Can we, like we have a strategic oil reserve, can we have a strategic cyber reserve where once Microsoft's servers are shut down, we say, well, it's okay, we've got other servers, or something like that you can translate to. How we do this is going. I think it's something we need to wrestle with and get better at than we're doing right now. Bill.
Mike, thanks very much for getting me here. It's good to be here. I admire your endurance. I really do. I'm going to take you, if I can, in the time available, through weapons law. And I'm going to try and show how some of it, at least, applies in relation to cyber. My starting off point is means of warfare, weapons platforms, associated equipment used directly to deliver force during hostilities. Methods of warfare, on the other hand, ways in which weapons are used. And then you ask yourself, well, that's great, but how possibly can cyber constitute a weapon? Because after all, a cyber activity in this context consists of doing that. Think to yourself about a rifle. I don't think many people would dispute the fact that a rifle constitutes a weapon. What are you doing when you're firing a rifle? That. And that has a certain effect in that a firing pin engages a bullet which passes the muzzle, at which stage it has caused no damage to anybody. It then goes through a medium called the air, and it then impacts a target, causing damage, injury, destruction, or death. I think there's a fairly useful parallel there for us to muse on. So a cyber weapon is any computer equipment or computer device which generates an offensive capability which can be applied to a person or object. That's not a perfect definition because you'd need to wrap in notions of use, you'd need to wrap in notions of intent and notions of design, but you get the general drift. So it follows that while there may be numerous orders of effect following a cyber operation, damage or injury at any order of effect has the capability of rendering that cyber tool that was used a cyber weapon. And if it is a cyber weapon, then certain things follow, like the application of weapons law. The nuclear weapons case tells us that the principles and rules of the law of armed conflict apply to all kinds of weapons, and that would seem to me, certainly, to include cyber weapons. So that would in turn suggest that the right to the parties to an armed conflict to choose methods or means of cyber warfare is not an unlimited right. It would also suggest that it's prohibited to employ cyber weapons and material and methods of warfare of a nature to cause superfluous injury or unnecessary suffering. So when we're looking at a cyber weapon, we compare the nature and the scale of the generic military advantage to be anticipated from the use of that particular weapon, and we look at the pattern of injury and suffering to be expected in association with its normal or indeed its intended use. But usually, a cyber weapon is prepared for a specific target or operation. So ad hoc circumstances, it seems to me, must be carefully considered when you are applying that test. And then, of course, we have the other significant customary principle in relation to the law of weaponry, the prohibition on weapons which are indiscriminate by nature. This is particularly potentially relevant in the case of cyber weapons, the critical issue being whether the cyber weapon limits the damaging effect reasonably to the intended target, and in that context consider certain types of worms, certain types of virus, certain types of malware that spread their effects uncontrollably. Planning cyber attacks, as we've already heard, is clearly going to place demands, very pressing demands I would suggest, on intelligence resources. Are they available? Are they up to the mark? If you're actually conducting a review, a legal review of a cyber weapon, I suggest that that is part of the package that you need to be concerned about. And then remember Article 35.3 of Protocol 1, the prohibition on the employment of weapons or means of warfare which are intended or may be expected to cause widespread, long-term and severe damage to the natural environment. We all know that that's one of the good reasons why the US is not a party to that particular treaty, but do remember, your allies probably are. And then there's the ENMOD, the Environmental Modification Convention, the prohibition on engaging in military or any other hostile use of environmental modification techniques having widespread, long-lasting or severe effects as the means of destruction, damage or injury to any other state party. That's fundamentally what the convention is all about. So look, I suggest, at the second and third order effects to determine if those rules are relevant. Think about a cyber weapon, for instance, designed to cause the core, we've heard about this example already, the core of a nuclear electrical generating station to ignite and thus render a large land area uninhabitable for very protracted periods. That may breach, conceivably, the Protocol 1 environmental rule. And then remember the rules in relation to poisons, poisoned weapons, asphyxiating gases, biological and chemical weapons. Cyber operations may enable a party to the conflict to gain effective control over weapons of that nature or substances of that nature previously belonging to the adverse party. The relevant treaties, if you look at them very carefully, place onerous duties on states that have control, amongst other things. Ownership, possession, jurisdiction, or control is usually what the treaty is talking about. It seems to me that you need to establish a national position on whether cyber control is control for these purposes. I personally suspect not, or at least not necessarily. Because in my view, what you would need to have is that sort of degree of control as to render it practicable for you to be able to discharge whatever the particular obligation or duty is that the treaty is imposing, whether it's in the form of corralling in the weaponry to a place of safety or whether it's disposing of them, destroying them, whatever it might be. So let's move on to CCW. Conventional Weapons Convention, Protocol 3, incendiaries. That prohibits making a military objective located within a concentration of civilians the object of attack by air-delivered incendiary weapons, and indeed by ground-based incendiaries absent restricted circumstances. So imagine a state taking control of an enemy air-delivered weapon belonging to another state with a view to redirecting that weapon against that other state. Clearly, if the weapon concerned is an incendiary weapon, any such redirection operation would need to comply, it seems to me, with the provisions of Protocol 3. That always, of course, assumes that when you take control of it, you know that it's an incendiary weapon. But that's a separate issue that raises all sorts of other potential questions. Think then about Protocol 4 to CCW, the laser, blinding laser protocol. If a laser has the power to cause permanent blindness, it would seem to be unlawful to design a cyber tool to cause, as a combat function, blindness by directing the laser beam towards the line of sight of enemy personnel. Mines don't really see the relevance in relation to mines because of the element of explosion that's critical to the definition of mines. But thank you, Eric, for the issue in relation to booby traps. Imagine a cyber kill switch in a piece of malware planted by cyber means into the targeted computer system, and which operates unexpectedly when a user of the target computer system undertakes what is usually a safe task, such as switching on the computer. It could only be a booby trap, of course, if it's designed, constructed, or adapted to kill or injure. So then we get into the question, what if the kill switch is designed to disable the electricity supply to essential life support facilities? Again, we're into territory, it seems to me, where a national interpretation is required. Is it a booby trap? Because if it is a booby trap, Articles 3, 7, and 9 to 14, plus elements of the technical annex to the protocol, AP2, amended Protocol 2, applies. That protocol also deals with other devices. Manually emplaced munitions and devices is what it talks about. So that will clearly, the manual emplaced element will clearly exclude devices which are put in remotely by email. What about a thumb drive bearing the malware that is manually inserted to the target computer system? You're putting in the thumb drive itself. Perhaps the cyber weapon is distinct from the gadget that conveys it. So the thing that's being manually emplaced is not the cyber weapon. That's an argument, certainly. But others may disagree. Applying the rifle analogy, for instance, they may have a point. Again, a matter, it seems to me, for state interpretation. A state that is party to the Cluster Munitions Convention, that by cyber means takes control of an adverse party's cluster munitions, for instance carried on a drone, may not use them in breach of the convention and must safeguard and destroy the weapons, again to the extent that the degree of control by cyber means permits. And what about weapons reviews? Article 36 of AP1 applies to cyber and non-cyber weapons, it seems to me. Now, traditionally, targeting advice is given to commanders under Article 82 of Protocol 1, and traditionally that advice is distinct from the advice that is given more usually to national procurement authorities in relation to procurement decisions apropos weapons. But the nature of cyber warfare, as discriminate or otherwise, and the nature and extent of the generic injury and suffering it will cause will likely fundamentally depend on the nature, linkages, dependencies, and customer base of the target computer system. So realistic weapons law advice can only be given when those variables in practice are known. This is this element of you're designing a cyber weapon for a particular operation. So the operational commander probably will not know in advance that the weapon as such that he's planning on using actually complies with weapons law, let alone whether the actual attack complies with targeting law. Consequently, it seems to me, the operational lawyer on the staff of those commanders increasingly will need to build in both weapons law advice and targeting law advice into the advice that's given. I think legal review of all cyber weapons should, however, continue generically in the procurement loop as of now. Why? Because the treaty requires it. Now consider some particular issues raised by certain particular kinds of cyber tool. Say a network of infected computers sends spam messages to the target computer system, exhausting its bandwidth and denying its normal service. A sort of DDoS attack. Generally no lasting effect on the targeted system, and the effect lasts as long as the botnet is in operation. So the effect may be inconvenience, not damage. It may therefore not be a cyber weapon. But if the targeted system provides the life support services whose interruption will foreseeably cause death or injury, the cyber tool does become arguably a weapon, requiring legal review. So would the weapon be indiscriminate by nature, you would need to ask yourself. But it's only death, injury, damage or destruction to protected persons or objects that would be relevant here, it seems to me, not inconvenience. We've spoken already about booby traps and other devices, so let me move on to a masquerade cyber tool which creates a computer system that mimics the target computer system whose customers are diverted to the masquerade system, which is infested with malware and or they're given false information. Again, it's only when the masquerade operation is designed or intended to cause death, injury or damage that the cyber tool arguably becomes a cyber weapon requiring legal review. But how do you make the weapon discriminating if it infects all visitors? Maybe you don't have a problem. Maybe all visitors are military in character. So you need to know something about who the visitors are, which takes me back to the point I made earlier about it being critical in the legal review of the weapon's capability to know something about the linkages of the system, how it works, how it interacts, what its dependencies, and so on are. Future research and development should aim, it seems to me, to enhance the ability of a cyber attacker to control and limit the effects of cyber weapons. This implies the need to be able to direct the weapon with growing accuracy and reliability at the intended target, to limit its effects to that target, and to be able to switch off the damaging operations if events do not proceed as intended. An ability to control, monitor, and even reverse cyber effects would seem to be something that will become more of an issue in the future. And the final point, in relation to weapons reviews, always remember that your nation is in the lead where actually conducting weapons reviews is concerned. You have been doing it longer than anyone else, and you have done more than anyone else. So that's one area of international law where you really ought to be patting yourselves on the back. Thank you very much.
What I think we can all agree on is that the three speakers in this last session today have provided lots of material and presented their arguments and ideas in a very interesting and learned way. So I hope you'll agree with me and join me in expressing our gratitude.